We recently won an interesting case before the Italian Supreme Court that deals with copyright law and the restrictions typically contained in license agreements. In this case, there was a software license agreement providing that the licensee could not sublicense the rights to another party. However, the license agreement did not mention that the licensee could not transfer the entire contract to another company. Afterwards, the licensee transferred its business and the software license agreement to another company, and the software owner claimed that the transfer was in breach of the agreement and that accordingly the purchaser of the business was using the software without consent. A provision in the Italian Civil Code states that in case of transfer of business, all contracts relating to the operation of the business are automatically assigned to the purchaser of the business. Accordingly, the licensee and the purchaser of the business claimed that no consent was required from the software owner. The Italian Supreme Court rejected all such defenses and clarified that the purpose of a license agreement is the granting of usage rights over work. Accordingly, a provision in a license agreement according to which the licensee cannot transfer its rights to a third party is equivalent to a provision whereby the licensee cannot transfer the entire contract to another party, as the two provisions have the same effect. This is also in line with the general principle that when it comes to copyright law, the copyright owner is entitled to an absolute control over the work. The decision clearly lays down a favorable principle to copyright owners, but it is also very interesting for legal counsels from a drafting perspective and also a negotiation strategy perspective. Most importantly, this principle will be applicable to all copyright licenses and not only to software licenses, as in Europe and Italy the software is protected by copyright law. Thanks for your attention and don't forget to follow our Lawyers Monday.